just hold October isn't there. 기사가 정지지가 없어.
아이고님이요. 그들이 살아야 돼.
수련회 rules doesn't it's a provision but to the he wants me to go back again.
E continuano a delle decisioni di forze sul lavoro. Non disposta a dello fare crescere.
I have filed it within time. There are we just to the fresh files in India. That limitation, that only that parties to sing. Yeah. It gets slap, pushle. Dirich modu.
Hello, hello. Admission item number 8.
May I please, my lord? Lordship, I beg to mention the hearing item number 13. 13, on behalf of additional GV Shokre. Your lordship, she has some personal difficulties. Your lordship, if this matter can be listed after 2 weeks. I'm informed that she has already taken the consent of the other side.
You're mentioning on behalf of?
Additional GV Shokre.
Okay. Learned advocate. Mr. Government advocate. Appearing on behalf of additional advocate G.
V Shokre.
V. Shokre. Praise for 2 weeks. Praise for listing the matter after 2 weeks.
Yes.
As Ms. G. Shokre has some personal difficulties. this week.
Please, Your Lordship, Lordship here,
And council also informed that this okay has obtained consent from the other side. Okay. Prayer allowed, least the matter after 2 weeks.
Lordship,
Okay.
let it come up on 30th November.
Oh, you are for the petitioner?
Petition.
Okay, then land council for the petitioner also. Huh?
30 November.
Okay,
yes.
is pray for the land council for the parties, least the matter after,
On 30 November. Yes,
30 November. Why
Lordship, that
30
is,
November?
could mean time.
After 3 weeks, we'll say,
Lord, this,
no, as a list, as a fixed matter, why?
Lordship, yes. Because it becomes inconvenient for the other council also to get an appropriate date. Prior-
Is it okay?
Lordship.
Okay, better come up on 30. Okay.
Your Lordship, I also beg to mention item number 11. Here, Your Lordship, I have been instructed to appear for respondent number 1,
Item?
11, in the order column, Your Lordship.
Yes, yes.
Yes, Your Lordship, I will be appearing for respondent number 1. I've got instruction to appear. So if 3 weeks' time can kindly be granted to me, Your Lordship.
no objection, Your Lordship, I'm for a petition.
Okay. Our land counsel for the petitioner, as well as land advocate, Mr. You are for respondent number 3,
No, respondent number 1,
1.
1, Your Lordship.
Okay, respondent number 1, Mr. Land, Mr.
And Angami, Your Lordship.
And Angami, I'm sorry. Angami prays for
3 weeks' time, Your Lordship.
3 weeks' time. Yes, he would be appearing on behalf. Earlier you appeared or?
No, Your Lordship, this is the first time I'm appearing, Your
Okay, yes, he would be appearing on behalf of the respondent number 1.
Your Lordship.
Okay, prayer allowed. List matter after 3 weeks.
Deeply obliged.
Okay.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 4 and 5, Your Lordship.
4 and 5. Yes.
Please, Your Lordship. Your Lordship, we have to file one IE for the stay of the impugned judgment. So, another 2 weeks' time may be granted
You are for
for the appellants.
appellant. Okay.
I'm for appearing for respondent number 2 and 3.
No objection.
No,
Okay.
Lordship,
I'm
appearing for 4 and 5, sir.
You are for 4 and 5. And you are for
respondent number 2 and 3.
2 and 3. And who is for 1?
He's also from Dimapur. I guess he has
We have already informed the
he's
council.
not here this morning.
Okay. Your good name, please.
Is that cool?
Okay. Learned counsel, Mr. So, learned counsel for the appellant submits that he has to file.
I may be allowed to file, I may be allowed 2 weeks' time to
Prays for
file,
allowing him to file a miscellaneous application for stay of the
impugned order,
impugned order, for which he needs 2 weeks time.
2 weeks' time.
2 weeks time. Learned counsel for the land advocate, Mr.
CD Rumsu.
For appearing on behalf of respondent number 2 and 3, and Mr.
And so, Your Lordship.
M.
So,
Appearing on behalf of the respondent number 4 and 5 has no objection. In view of the above, the prayer is granted. List the matter after 2 weeks.
Much
2
appreciated.
weeks.
Your Lordship, I also beg to mention item number 7.
Item-
I'm making a mention on behalf of the private counsel, Mr. Y.P. Gupta. Your Lordship, he is indisposed.
Okay, you are mentioning on behalf of
Mr. Y.P. Gupta.
YP Gupta is for the respondent. YP Gupta is for the respondent,
For the private respondent.
private respondent number,
2.
not private, and you are for,
I'm for the petitioner, Your Lordship.
you are for the petitioner.
Yes, Lordship.
Planning counsel for the petitioner, Mr. Swen.
I'm for Your Lordship. I'm for on behalf of Mr. P.P. Paul.
Also have Mr.
Zat Kullu on behalf of Mr. Y.P. Gupta.
Red Kun appearing on behalf of the behalf of Mr. Y.P. Gupta, planning counsel for the respondent. He prays for 2 weeks.
2 weeks time.
As Mr. Gupta is. As Mr. Gupta is,
Indisposed.
okay, indisposed, stop. In view of the above, the prayer is allowed. Case is John, next day, sorry, list the matter after 2
2
weeks.
weeks.
Okay,
Much obliged.
May I please, my lord?
yes,
Lordship, I beg to mention item number 6 on behalf of my colleague, Livika.
yes,
Lordship, I'm told that she is here to file her counter affidavit in this matter. If 3 weeks' time can be granted, your lordship, to file counter affidavit?
Learned Advocate Mr. Angami. Learned Advocate, appearing on behalf of
Miss Livika.
Ms. Evika. Press for adjournment of the case for 3 weeks. 3 weeks, stop. Learned Advocate Mr. You are for respondent,
My lord, no, I'm the petitioner.
and Evika is
For the state.
for respondent,
Yeah, for the state respondent,
for the state respondent.
lordship.
So say state respondent, huh? And you are for?
And for respond number 1, Lordship, I have already filed my counter.
Okay. In the earlier, then we'll say that she has yet to file
Counter affidavit,
counter affidavit.
lordship.
Okay, and praise for 3 weeks time. So. Learned Advocate, please,
Miss Lucino for respond number 1.
you have already filed.
Yes,
She
Lordship.
is also present and submitted. She has filed a counter affidavit on behalf of the respondent number
1, Lordship.
1, stop. Learned counsel for the petitioner, Mr.
Elizabeth,
Zero has no objection to the prayer, no objection to the prayer above prayer, stop, the prayer allowed. This the matter after 2 weeks, 3 weeks,
3 weeks.
3 weeks, okay.
Obliged, my lord.
For motion, item number 1.
may I please your lordship.
Yes,
My lord, I'm aggrieved by the interim order. Interim order dated 20 October 2020. 22. Annexure D, page 28.
page 38,
28, my lord.
okay,
Yeah. Translated copy is on page 30.
yes.
Translated copy.
Mm.
My lord, this is a matter in regard to a irrigational canal. My lord, I'm one of the party who enjoy the canal, the water from the canal. Now, the opposite parties claim that this water does not belong to me. So this matter was highlighted before the village council court. Thereafter, the village council court has passed an order against me stating that I have no claim over this irrigational water. Then after that, since I'm being aggrieved, I approached the DB court at PAC.
What is DB code?
DB is the Dobashi's court.
The buses,
Yes, the Dobashi court comes under this thing, Rule for Administration of Justice and Police Act. Rule for Administration of Justice and Police.
Okay. Okay,
So,
so this is under just a minute. Rules for the administration of justice and police.
yes, my lord, Rule 24, page 28.
Rule,
So, yeah, Rule 24, page 28. Page 28, Rule 24.
yes,
Yes. Masuda Gambura chiefs
Where are you
Hetman
reading? 24, page 28.
28.
Just a minute. Okay, rule 24.
Yes, 28.
Hmm.
Rule 24, I read.
Yes, please.
Mazudar Gambura, chief headman of Khels, Dobashis. So, under the rule, the Dobashis also can decide case. So this particular case,
Dobasi said, just a minute. Or other rules. They could try cases without limit.
without limit as to the amount. And my lord, coming to rule 32, that is on page 39. Page 39,
Yes,
new rule 32.
yes.
So new rule 32, 1984 amendment. 32, I read.
Yes.
The High Court or the Deputy Commissioner may, on an application by the aggrieved party. So,
The High Court or the Deputy Commissioner. may.
yes. So I am filing this particular case under Rule 32, being aggrieved by the order of the DB's court.
So these Dobasis used to maintain records also.
Yes,
Okay. How many person consists the Dobasis authority?
my lord, it varies.
Okay,
In the district of Peck, I'm not very certain. Here in Kohima, it consists of 9 or 7 like that,
and headed by
and headed by the head DB,
oh,
head Dobashi.
head Dobasi.
Yes, my lord.
There used to be only one, the head Dobasi in there.
Only one, yes.
Okay,
So, my lord, in the order, that is page 30 of my application.
so this, yours is, this is revision.
My lord, I am aggrieved by the order of the head DB Peck.
Whether appeal lies against the,
My lord,
appeal lies to,
appeal
Lies
lies
before?
under this rule 32.
appeal under rule 32.
Yes,
But you have come,
either the High Court or the DC.
the High Court or the DC may on an application.
Yes.
Says that by way of appeal, if any,
Yes,
but that you have come before this court by way of
revision.
revision.
Yes, my lord.
How?
My lord, this
The
honorable
provision-
court,
Hmm,
I find my case under under 151
yes,
of the
that is,
CPC.
okay.
Yeah. 151 of the CPC.
But you have mentioned section 115 revision.
My lord, page
Whether
2,
this is appeal or revision.
it's revision.
Whether revision provision is also provided under these
Yes,
rules. Where?
my lord, under CPC,
Under CPC.
yes. 151. 151 of the CPC inherent power of the court. So this High Court has the inherent power to entertain this particular case.
Yes, provided that the party agrees. Can you just read the proviso to rule 32? Can we
Yes.
just?
Yeah. Provided that the aggrieved party may move such application only after availing the remedy by way of appeal, if any, provided under the rule against such decision. Now, here, my lord, the head DB is the highest court,
Okay,
yes, before the district. Now, this matter can be taken up by the deputy commissioner also. But why I have appealed before this honorable court is that I have made an application to the deputy commissioner at HAC. Now, the deputy commissioner at HAC should have taken up the matter, but has endorsed this particular case to the head DB. So, since I have availed the opportunity to fight, to present before the DB, the DC, since the DC has endorsed it to the DB at DB.
so initially you filed before the DC only.
Exactly.
So DC endorsed it to the basis.
Yes. Now the DC cannot take up the matter.
Hmm.
As for that, I am approaching this honorable court.
So this is revision,
My lord,
not appeal.
no.
Is there also any appeal provision here under these rules? Under this, justice and police?
My lord, it's exhausted.
Hmm?
Under this rule, it's exhausted. Because I've made an appeal before the DC.
Whether the impugn order is the final order?
Yes,
So you have come by way of revision, not by appeal? By
No.
way of appeal, right?
revision. So
Why?
that this honorable court can give a direction, can pass a direction, so that this matter can take up before a proper civil court. Now here, my lord, in this particular case, parties were not examined. Witnesses were not examined.
Okay,
And the DB court has passed a decision. And that decision was passed so that I can file appeal within 10 days' time.
Hmm.
Now, since the DB has passed an order for an appeal within 10 days,
Hmm.
that 10 days was not notified to me. The order, when the order was passed, also was not notified to me. I've applied before the DB court for an order. That also was not given to me. And only through my cousin, this order was given.
When the matter was taken up
Yes,
for DB,
yes.
whether you were also present,
Of course,
you participated.
yes.
Order was made on that day only.
Order was passed on that day.
Hmm.
And then on that day, the court should have instructed that this order will be passed on this very day. But that was not notified to me.
Is there any limitation prescribed under this rule?
No,
No limitation.
yes, it's 30 days only. But here the DB court, instead of giving me the order, the DB court has not given me the order.
What do you mean by 30 days? The limitation
Yes.
is 30 days.
Yes,
30
but here in this particular order, in the present case order,
Okay.
the
So
present case
where-
order,
Where do we find that 30 days?
pardon?
30 days, limitation 30 days, where do we find? Limitation prescribed under this rule,
Yes,
where do we find? Under which rules?
it's all 30 days.
Where?
Uh,
This is,
My lord, here in page 37. Page 37, rule 29,
yes,
yes. So an appeal lies to the deputy commissioner against the decision of any of his assistants. Now, my lord, come to the proviso number 2. Provided further that the appeal may be admitted after the aforesaid period of 30 days.
So when the order was passed in this case,
This case was passed
impugned
on
order,
20 October 2022,
what is the impugned order?
page 30. Translated copy.
20 October, and then when have you filed this one, this revision petition?
My lord,
Okay, so October, November,
yes,
still you have a time.
20 October 2022. My lord, I may be allowed to read.
But then the, yes, which one?
Yeah, I may be allowed to read this particular order.
Okay,
Yes. Page 30, my lord.
yes,
On dated 20 October 22, as per the summon issued dated 10 October 22, we have reached the spot and pursued the case. Findings of the right of the complainant and the defendant. I have a share in SEPI irrigation water. Above my big terrace peripheral, 3 terrace field, I have been cultivating the field. However, the same was sold to one Srimati Yehalo. If I have no water, would I cultivate it? River water is used for another field. Therefore, in this SEPI irrigation water, we surely have our share, as stated. This was stated by me. Now the opposite party, number 2. In this SEPI irrigation canal, Yavacha tenure has no water right on wet paddy field as well as dry paddy field. It is also stated that in the earlier irrigation construction, Sri so-and-so has been cut chase off twice.
who was changed of twice?
That is my father
By,
by the opposite parties. That was the allegation.
who are the opposite parties?
The opposite parties are the respondent 1 to
They
27.
are individual person or the community?
They are the individual person.
Okay,
Yes. My lord, coming to page
Yes.
31.
Mm.
Findings in the examination, even if the drain water from the village water is used for cultivation, there is no restriction and this water route belongs to him. That is me. However, in the SEPI irrigation water, Yavacha having his share was not found. Therefore, the village council joint court decision shall stand. In this manner, the DP court has rendered its decision on dated 20 October 22. Aggrieved party should make an appeal in the High Court on or before 30 October 2022. Otherwise, the decision shall be followed as by me. Enclosed joint court decision of Middle and Upper Komi village on 9 September 2022. And this has been signed by the opposite party.
what is the custom here? Say river, this is a river or canal?
It's a canal.
Canal,
Yes,
this is constructed one,
yes, it is a constructed one.
not the natural one.
No,
Who constructed it?
it is jointly constructed by the villagers,
Villagers, including
Yes.
you.
even me also.
Okay,
But here they are stating that my father has been chased twice. Now I have a field and that particular field, I have been enjoying this water.
Hmm.
And all of a sudden, they said that I have no share in this water. So that is the allegation. Now here in this particular case, no witnesses were called for. No witnesses were examined. And the decision of the decision of the DB court was made in such a way that this order also was not given to me. I've already asked for the copy of the order, but this copy of the order also was not given.
So that means you have also paddy field there, over there.
Yes, I've been enjoying. My lord, in order to
Whether
make this
such-
better clear,
Whether such things had happened earlier also in some other village or nearby, that the water, natural water coming for the irrigation is not being allowed to some particular person.
in other cases, only there.
It happened.
It is there.
It is there.
Yes.
So,
But in other cases,
Hmm.
since the court cannot assert if, after going through this thing. the
then
case-
what happened generally, then thereafter, if the person is not allowed
Yes,
to access the water from the irrigation, and what will happen to his paddy field? Generally, what use?
my paddy field will be of no use.
Hmm.
So for that, I'm filing this application before this honorable court.
Then what happened to other cases? Say, for example, like this, the cases you
Yeah.
told, that it had happened in other
In
cases.
this kind of cases,
In such.
yes, in this kind of cases,
Hmm.
the high court usually sends the matter to the lower court
Hmm.
for a proper trial. In a civil court, not in a DB's court, but in a civil court where the witnesses are called for, examine, and then after that, proper order are being passed. So my lord, here in my application, that is on page 10.
Yes, what is that?
Page 10.
Hmm.
My lord will be very clear after going through this. May I read?
Yes,
Yeah.
Para,
That case in brief is that the petitioner here in
page
is
10,
page 10. 10.
okay.
Yes. That the case in brief is that the petitioner herein is the son of late Kerry Cho and the inheritor of Chikuza, who expired on 7/7/2007. That the paddy field at Chopelo or Kenut Law, that since time immemorial, the present petitioner family enjoys the Sepi irrigation canal. So, my lord, this is clear that prior to 2007 and prior to this institution of this case, I have a paddy field I have been enjoys the Sepi irrigation canal for the use of his field. So also his father, so and so, who is none other than his father, elder brother, from whom he inherited the field at Chopelo. Further, the petitioner family owns the irrigation canal, which was drained down from the village to his second paddy field, as admitted by the opposite party. The petitioner herein, the petitioner's father herein, due to financial constraint, sold a portion of his paddy field at Chopelo to one Mrs. Shareholder on data so and so. And that this clearly indicates that the petitioner family also enjoys the right over the Sepi irrigation water for cultivation. Likewise, Mrs. Shareholder enjoys the right of the Sepi water.
So this Mrs. Yellow is still enjoying.
Yes,
Okay, is there any other water sources also other than this canal, irrigation canal?
in this,
For you, suppose if you are debarred, and is there any other water sources for a paddy field?
no,
No, this is the only
Yes.
sources.
yes.
Okay.
I have two field in that particular area. So in this case, in the present disputed case, I have sold a portion of my land to a lady. So she is enjoying. Now the opposite parties, member in 27, they want to debar me out of this. So my whole case is this.
So this is only because your father was chased, or is there any other reason for debarring?
That is the allegation made by the opposite party.
Okay,
Yes,
okay. Will issue notice?
my lord.
This is a civil revision petition under section 32 within bracket new of the rules for administration of justice and police in Nagaland Act 1984, read with section 115, 151, and 151 of the Code of Civil Procedure 1908. Stop. Just a minute, sir. The petitioner is aggrieved by the revision petitioner is aggrieved by the impugned order dated 2010, 2020, 22.
My lord.
This was passed in 22 only.
Yes, my lord.
No. See, now if it is on 20 October 2022,
Yes,
now this is 2023.
yes,
1 year passed.
exactly.
Then you have come after.
That is exactly what I'm saying, my lord.
No, then the limitation is 30 days, you said.
Exactly.
Then
Now the DB court has not furnished me the copy of this particular order.
have you applied?
Yes,
Where is the document that you have applied?
I've applied before the DB court. But the DB court has not given it to me.
Where is the copy? What is the copy by which you have applied?
What I've applied is with the DB's court.
Now, where is the copy? Have you annexed the copy?
My lord, I've already submitted to the DB.
Then probably I think you have to file for the condonation of delay also.
My lord, I have
I thought
mentioned
this is
in my
2023.
listing.
Hmm?
My lord, I have mentioned in my listing, para
Right.
13.
What have you mentioned?
Yes,
What have you mentioned?
para 13, page 14. That only on 9 October 23, the
Para
copy of,
13. That only, okay, yes.
yes, the copy of the order was furnished to me.
No, because on the day when the impugned order was passed, you were also present.
Yes.
And then it was informed to you also.
No, I was not informed that the order will be passed on that particular day. I was not informed.
Order was not passed on that day.
Order was passed on that day.
Hmm.
I was present,
Yes.
but after my leaving, the order has been passed. I appeared on that particular day.
Hmm.
I was there before the court.
The court was decided in
The
your
court,
presence.
the court was to decide.
Court was not yet decided.
The
Why
court
you-
has not decided it yet.
Hmm.
Now, after my leaving, the court has passed the order on that particular day.
Why you have left the court then?
Because the matter is finished. And I didn't know the intention of
They
the
kept the,
DB that
they kept
they
the
will
order,
pass
they kept the order reserved on that day.
the court has heard us.
Hmm.
The court has never informed the parties that they will pass the order on that particular day. So since the matter has been completed, I have left the court. Now, in my absence, the court has passed this particular order.
But then immediately after the court had passed the order, you came to passing of the order, said order.
No. I've been informed after some days. After that, I went to get the order. Then the DB court did not furnish me the copy.
And my question is whether you applied for the certified copy of the order.
Exactly,
Where is the copy?
that copy is with the DB's court.
Davis court,
Yes,
not with you.
not with me.
And you see, if there is any limitation, if the limitation act also attract, then how
Exactly, exactly.
How do we entertain?
My lord, in order to clear the doubt of the court,
Hmm.
this honorable court can ask the copy, the orders, the records of the DB court. Whether my petition has been forwarded before the DBs or not. I've asked verbally, I've made the application to the DB court.
Have
And
you also-
here-
Have you also made party to the government?
Pardon?
Have you also made party to the government?
No, my lord.
Then who will represent this DB? Who generally represent this DB in the court?
Nobody.
DB
Nobody.
is a court
DB is a court.
and it's a government.
Yes,
Government doesn't represent this.
no,
No.
no.
Your Lordship, here, the Overseas Court is a court instituted during the British time, and this court mainly entertained the customary cases. And as per the rule against that he passed the judgment. So that's a status of the court.
So who used to represent them?
No,
This
no, no,
DB?
it's a court, customary court.
Okay, customary court.
Yes,
But then it was endorsed by the deputy commissioner.
yes.
You don't make deputy commissioner.
I've made application, being agreed by the village council court, I've made
Okay.
application to the
Okay,
DC. Now the DC has endorsed into the DB court.
okay. The petitioner is aggrieved by the impugned order dated 2010-2022, passed by the head DB's court. What do we call head DB's court? What do we call this? Head DB's court? Only head DB's court,
My lord,
heck,
yes.
Nagaland. In miscellaneous miss slash civil slash case number 102 slash 2022. Which is under challenged, alleging that by the said order, the court have acted in the exercise of its jurisdiction illegally and with material irregularity. Stop. Huh? The land counsel for the petitioner also submits that although so he was not informed about the passing of.
No.
Okay.
Yes, he was not informed. The DB court also ought to have given me an order, copy of an order. That also was not furnished to me.
The land counsel for the petitioner also submits that the order passed on 2010-2022 was not furnished to him despite, although he had applied for the certified copy of the said order, and it was furnished to him only on 9th of
October
9/10/2023
23. That also through my cousin.
through your cousin.
Yes,
What is his name?
my lord, I have not asked for this thing.
Hmm.
That was the information given to me by my.
Through his cousin.
Yes.
Okay, through his cousin. Stop. Dana counsel for the petitioner, Mr. So, staff, issue notice returnable by 4 weeks. Staff. The petitioner shall take necessary steps for necessary step for steps within
1 week.
1 week. Stop, list the matter after 4 weeks.
Okay.
For admission, item number 2.
May please, your lordship.
Yes.
My lord here,
Just a minute. In that case, you take steps by to register with AD. Steps. Steps to be taken by register with AD. Okay. Okay. Yes, this is item 2.
Yes, Lord.
yes,
Yes, please.
your lordship here, of course, this contempt is pending since 2019. But regarding this, in this contempt, the nature of the case is such that it involves 2 communities. So the state also, as per the direction of the honorable court, the state, step by step, we are taking steps. But now it is coming to a conclusion to file the complaints. So the state government, where we were compelled to negotiate with the communities. Otherwise, it is not easy to mingle the villagers by order. So now at this stage, I have been taking sufficient time from the court, but the nature of the case is such, is very sensitive. So now we have already invited the displaced person to give the consent, and tomorrow, 7th of November, is the last date. So after submitting this, we have to work out the modalities in order to comply the direction of the honorable court. So, your lordship, I pray for 4 weeks' time to comply the order of the honorable court. So. Your lordship, that correspondence given by the department is, I'm submitting a copy that, we have invited displaced people to give their consent so as to accommodate in the same original village. Otherwise, your lordship, here, as per the direction of the honorable court, we have been complying the direction of the honorable court by issuing the indigenous situation certificate. Everything we have already done. But now the part is only for settlement. So particularly for that settlement of the displaced person, we have inviting, and tomorrow is the last date. Then after that, we have to work out the modalities. So we require some more time to comply the direction of the honorable court.
Who is for the petitioner?
I'm for the petition, Lordship.
Okay.
Lordship, if I may
So-
also be allowed to produce this letter we have received from the office of the ADC, Lordship.
No.
Here, Lordship, in this letter, Your Lordship, we have been asked to submit a written consent if we are willing to return to the village, Lordship. So we are willing to do that, and we are in the process of doing that. So if this matter can come up after 3 weeks, Lordship, and then in the meantime, if all these documents, all these letters, which the additional AG is producing, can be brought into record through an affidavit, Lordship, I think that would be more appropriate.
So yes, that would be appropriate to bring it into record.
Yeah, your lordship,
Affidavit.
yes, definitely. After completing all the steps, we'll submit the complaints report to the honorable court by way of affidavit.
Okay. Land counsel for the petitioner, Ms. Luzina
Yes, Lord.
and Mr. Im Kim Song. Land additional AG Nagaland appearing for respondent number 1 and 2. Stop. Land counsel for Lanet additional AG Nagaland Mr. Im Kim Song produced letter dated 2/11/2023 written by producing the letter dated 2/11/2023 submits that the government has taken steps for the resettlement of the displaced families.
Yes, Worship.
And the government is working on the modalities for their resettlement. Which may take some more time
Worship.
and praise for some more time accordingly. Praise for allowing the government some more time. Stop. Land counsel for the petitioner, Miss
Lucina, Lord.
also produced one circular dated 25/10/2023, whereby the government has the government has informed the villager who are willing to return to the village and ask them to submit written consent to the office of the additional deputy commissioner, Siyochung, Nagaland, on or before the 7th November 2023. So, both the letter dated. So you file it in the affidavit form? Yeah, okay. Is grateful by both. Under the circumstances, both the land counsel for the petitioner and the respondent prays for adjournment of the case for the adjournment of the case with the view to facilitate the government to take necessary steps and to complete taking necessary steps. Stop. The prayer for adjournment is allowed. List the matter after 4 weeks. In the meantime, the respondent shall file additional affidavit or miscellaneous application.
Your Worship, we may be allowed to file
Okay,
in the form of affidavit compliance
Okay,
report, compliance report.
okay, the respondent shall file affidavit.
By affidavit.
Okay. And bring the above letter into the notice of the court. No? bring this letter into the notice,
Yes,
on record, huh?
report.
On record stuff. Huh? This is matter of 4 weeks, okay?
After 4 weeks,
Yes.
For admission, item number 3.
Yeah, please, Lordship.
Yes,
Lordship, for the state respondent, Your Lordship. Lordship, another 3 weeks may be granted.
who is for the petitioner?
None appears.
None appears when the matter was called for staff.
Your Lordship, I've taken the consent, Your Lordship.
Okay.
I've taken the consent
However,
of the petition.
however, Miss
Livika, Your Lordship.
Lana Government Advocate, while informing this court that she has taken consent of the from the Land Council for the petitioner, prays for adjournment of the case for 3 weeks. In view of the above, the case is adjourned, list the matter after 3 weeks. Okay.
Much obliged, Your Lordship.
For admission, item number 8.
But please, Your Lordship, my senior is on legs. Can this matter may be possible for the time being?
Time being,
Yes, Your Lordship. He's on legs.
okay. We'll take up it as the last.
Yes, all right.
Oh, yes.
Yes, Mr. Lord.
Yes, please.
This is a case with regard to the regularization of the petitioner service. They are Ayush doctors in the Department of Health and Family Welfare. Way back in 2005-06, they were appointed on contract basis, and thereafter in 2007, an advertisement was issued. And then pursuant to the advertisement, the petitioners have responded and then appeared, and they were selected. And
Appear in the
thereafter-
examination.
But it was not on regular appointment,
Okay.
and then they were appointed for a period of 1 year. Thereafter, extensions were given from time to time.
On contract.
Yes, sometime in 2018, in view of the long services rendered by the petitioners, the department has came out with a policy to consider their cases for regularization because of the fact that all of them are over age and serving for more than 15 years. So keeping in view of that, proposal was initiated, and then rationalization, a manpower rationalization committee was appointed, and then they have considered the cases, and they have proposed for consideration for regularization of the petitioner service. It was sent to the PNR department. PNR department has also agreed, and the clearance of NPC was also obtained. That is in accordance with the standing provisions of law. In 2019, a virtual decision was taken by the cabinet to regularize our services. But what happened? Before this is finalized, in 2020, sometime in the month of March, Lordship is well aware, COVID-19 has struck the entire world. Therefore, the move for regularization of the petitioners have been kept on hold. And what happened? Another development took place during this time, in the month of June. In view of the COVID-19 pandemic, the medical department, they had a harrowing time, Lordship. Very tough time. That is not only in respect of the state of Nagaland, but in respect of all the states all over the country. So special recruitment drive were also made. New posts were also created during this time. And because we have to combat with the pandemic, COVID-19 pandemic. And another 11 posts were created. And then what they did, the group up together, 10 posts plus 11 newly created posts were clubbed together, and a decision was taken to consider our cases. But then what happened? Once our group is 10 persons, 10 doctors, Ayush doctors. Our
Petitioners are 10, only 10.
Yes, only 10. But then our case has been mixed up along with those 11 newly created posts which were created during COVID-19 period. And then it was sent for recruitment. Now, we are agreed by an order of the government which was issued on 2nd of November 2022, by which a decision was taken by the government to recruit, to fill up the post through a special recruitment board. Now, if that is done, then the initial proposal, which was made by the cabinet, initial decision, which has taken a decision to regularize our services.
Whether this initial decision of the minister.
Yes, cabinet has taken a decision.
It was brought into the notification.
Yes. But then what happened was, the 11 newly created posts, which are newly created, our case has been mixed up along with this before arriving to a final decision as per the initial proposal.
Final decision was yet to come.
Yes.
Not yet.
Now, no, final decision yet to come is.
With regards to the 10 post.
Kindly come to page 75.
Yes.
Annexure R. We are agreed by this and we are questioning this. We are not against the entire recruitment process. Okay, if you want to go for a special recruitment drive, you may go ahead, but that should be applied in respect of the newly created 11 posts which has been created during the COVID pandemic. And since we are the persons, doctors, who are serving more than 15 years, who have become overage also, therefore our cases should not be mixed up along with the 11 newly created posts. That is our grievance.
Your grievance is only that out of this 21 advertised on November,
yes,
the 10 should be kept reserved for.
Yes, Lordship. That should not be grouped together along with this group.
Okay.
So this process, let it go ahead. We have no objection because
what the RR says, RR for the.
Kindly serial number 3 at page 75.
Yes.
Our petition here, there are number of vacancies is shown as 21 post vacancies.
Okay.
But ours is only 10 persons.
Okay.
And 21 is including this newly created 11 posts. So to clarify this, can we come to another annexure, page 79. The principal director of the department has clearly stated in his letter, page 79, annexure T. This is 15 November 2022, written to the Commissioner and Secretary, Health and Family Welfare Department by the principal director, who is the head of the department.
Okay.
Lordship, has Lordship got it?
Yes.
Subject, segregation of 10 posts of medical officer Ayush from the 11 posts of medical officer Ayush created on exigency for COVID-19 containment. Sir, with reference to the recent notification white number so-and-so dated 2nd November 2022, this is what I have just referred to your lordship at page 75. About several category of posts to be recruited through the special recruitment drive. I would like to highlight some points in regard to the post of medical officer Ayush. As per the letter number so-and-so dated 25th June 2020, special recruitment drive during the pandemic in serial number 3, that is at page 75, serial number 3, it talks about medical Ayush doctors.
Yes.
Serial number 3, wherein it is mentioned about the newly created post of medical officer Ayush for 11 posts only. For 11 posts only. But in view of the COVID-19 pandemic, advertisement as per the order number so-and-so dated 16th of July 2020 was made, and consequently recruitment on temporary basis was done for 21 posts of medical officer Ayush. It may be mentioned here that the 10 posts of medical officer Ayush were existing prior to the pandemic, that is 8 posts created in 2018 and 2 existing vacancies. During the intervening period, 2 vacancies arose. So it comes to 10. Against this post, the case of 10 senior-most Ayush doctors who had rendered services for more than 15 years at that time was thoroughly examined by a committee set up by the government, consisting of representatives from Health and Family Welfare, PNAR, NPSC, and Directorate of Health and Family Welfare. The committee recommended for regularization of the group against then regular sanctioned posts based on certain conditions if they could be supported by documents, which the department fulfilled. However, the onset of COVID-19 along with emergency measures taken for containment of the pandemic interrupted the whole process, and the considered recommendation of the committee is yet to be brought back on track. Therefore, I want to request that the 10 regular sanctioned posts of medical officer Ayush mentioned above be segregated from the 11 posts of medical officer Ayush created for COVID-19 without bringing it within the purview of NPSC recruitment. I also want to request you to kindly initiate the process for regularization of the 10 senior Ayush doctors, which was withholding during the pandemic. It will be very grateful if you kindly do the needful from your end. So
this was written on 15/11.
This was on 15, yes, 11/20.
So the advertisement was done after this.
After this, nothing was done, and since the advertisement has already been issued, notification has already been issued, page 75, to make the recruitment through a special recruitment drive by the NPSC, unless we approach this honorable court and this honorable court intervene with this process. Then once the notification is issued for recruitment, then the ongoing process will be adversely affected. That is why the present petition has been filed, that these 10 doctors in respect of 10 doctors.
This page 75 is the advertisement for the recruitment.
Not advertisement, Lordship.
Whether advertisement already issued?
Not issued.
Not yet issued?
Yes.
Okay. Then
and the interim order was passed by the honorable court.
Interim is
that
there.
no recruitment should be
now
done in respect of 10.
Okay.
And Lordship, we are not against the recruitment process.
Right.
Let it go.
Yes.
But that should confine to the newly created 11 posts, as has been correctly mentioned by the principal director.
Saving 10 posts for you.
But government, since they have been working with a lot of pressures during the COVID, somehow, somewhere, something went wrong, and then our case has been clubbed together along with the newly created post. Our prayer is, our case, since it was already considered by a committee consisting of all the organs and the neutral department, that is the PNAR department, and the Nagaland Public Service Commission, they have all cleared. Therefore, our case should be left out and should not come within the purview of the 2nd November 2022 notification. This should confine only to the 11 doctors. And let the department do whatever they want to do
The post,
in respect of 10 posts.
post has not yet been forwarded to the Nagaland Public Service Commission for recruitment.
Lordship, as per this, kindly let us read page 75,
Yes.
annexure R.
Hmm.
Has your Lordship got it?
Yes.
May I read?
Yes.
In the interest of public service and on the approval of the cabinet 26/5/2022, the governor of Nagaland is pleased to notify the following posts to be recruited through a special recruitment drive as indicated below.
Okay.
And then our posts are in serial number
Yes.
3.
Yes. Yes.
And then down below in the paragraph 2, the special recruitment drive shall be conducted by the NPSC, Nagaland Public Service Commission, and the Nagaland Staff Selection Board. Down below, there are certain categories of posts which can be
No,
recruited
so
by.
it says the special recruitment drive shall be conducted by the Nagaland. My query is whether it has already been forwarded to Nagaland Public Service Commission.
No,
Not
not
yet.
yet.
Okay, and then after this, after stay, and then since your representation and it was under the consideration by the government, whether the
Yes.
government has taken steps thereafter,
No steps. have
no
been
further
taken.
steps.
Since the interim order was already passed by the government.
Uh,
So my only prayer is,
Hmm.
let, so far as 10 posts is concerned,
Hmm.
let this post not be mixed up along with the other
Yes.
11 newly created posts in terms of the 2nd November 2022 notification. It should be segregated along with 11 posts. And then leave the discretion with the department so as to complete with the ongoing process for consideration, Lordship.
So the government,
Otherwise, if we don't challenge this,
Hmm.
then it will be a hurdle for us that you have not challenged this at appropriate time.
Right.
And then after completion of the process, it will create more problem. That's why the petitioners have approached this honorable court. The respondent has already filed counter.
so,
There is nothing serious so far as the government affidavit is also.
so government, what, so
I'm looking for the
pleading completed. So this is in the admission column.
admission hearing.
Yes.
Admission
for
hearing.
admission hearing.
Okay. Yes,
Lordship, I'm representing the medical department, Lordship. In fact, my affidavit will cover even the chief secretary's side, Lordship. Now, the Lordship, as far as the case is concerned, we are not denying the fact that 8 posts were created prior to COVID. 11 posts were created during the COVID. But from 8, 2 more resultant vacancy was there. We are not denying that fact. A committee was constituted under the chairmanship of the principal secretary, PNR department, along with the medical department and other officials, Lordship. Now the committee has recommended for regularization. Thereafter, COVID came. The committee never went ahead. Now, as far as the recruitment of the petitioners are concerned, they are governed by the Nagaland Medical Service Rules, Lordship, where the post has to fill up through the Nagaland Public Service Commission on 100% basis. There is no question for other method of recruitment. There's only through the Public Service Commission. This is stand, Lordship. Lordship, now coming to my learner has not gone deep into the aspect of the matter, Lordship. But a committee was constituted, Lordship, where a minute was prepared. Lordship, may kindly come to annexure L, page 58.
38 of,
58 of the read petition, Lordship.
okay.
Annexure L.
Yes.
This page 59 is the minute, Lordship. 58 is the covering letter, how the meeting was conducted, Lordship. 58 is the minute of the proceeding.
Okay, then what we'll do, deeper consideration necessary, we'll admit it and fix it for hearing.
Lordship, I leave it to your Lordship, yes.
Yes, since as per the Land Council for the respondent, deeper consideration is necessary, we'll admit it and then release it for hearing.
Lordship.
Detailed hearing. Third. Just a minute, you are for the respondent, department, and
I'm
you are for,
correspondent number 1, Chief Secretary.
okay,
Yes.
I'm for respondent number 2 and 3. The medical part.
third, Mr. C.T. Zamir, Lieutenant General Counsel, assisted by,
I am Chen.
I am J. Lieutenant, okay. Also had. Three,
And Mozoy.
okay, Lieutenant Counsel appearing on behalf of the respondent number
2 and 3.
2 and 3.
Medical department.
Medical department. I've also heard Miss
Yes, maybe.
Lieutenant Counsel appearing on behalf of the respondent, sorry,
Respondent number
common
1.
advocate, huh?
1.
Appearing on behalf of the respondent number 1, stop, huh? The Lieutenant Counsel for the party submits that the pleadings are completed. The matter is ready for hearing. Stop, huh? Considering the contention made, rival contention made in the pleadings, and also after hearing the parties, I'm of the view that the matter needs a deeper consideration. And deeper consideration. So accordingly, this petition is admitted. List the matter. Admitted, stop. List the matter after. List the matter for hearing after 4 weeks. No, 3 weeks. Okay.
Obliged.
Obliged.
For admission, item number 9.
That is a lordship. Yes.
Lordship, here the petitioner is praying before this honorable court for Zima of the seized vehicle, Lordship. Lordship, on the last occasion, this honorable court has directed the state respondent to the investigating agency to conduct.
You are for
video
the?
conference. I'm for the state respondent.
State respondent. Who is for the petitioner?
The petitioner, they are
Oh,
video conference, Lordship.
yes.
So, Lordship, we have conducted a video conference as directed by this honorable court.
Yes.
I would like to produce the latest report, Lordship. Yes, David.
Yes, diary.
Lordship, this is the this is the NDPS case, Lordship. And here the petitioner are praying for Zima of the said vehicle which was seized, Lordship.
Any problem releasing the seized vehicle and Jimma at the stage when it was seized?
Lordship,
It's
it
been long,
was-
I think.
It was seized on 29/7/2022, Lordship.
22.
22, last year.
And
Lordship.
then this court also perhaps on 22/5/2023
Lordship,
has
directed,
directed to
Yes.
place on record
Lordship.
if the seized vehicle in question is still required for the purpose of investigation.
Yes, Lordship,
Is
required.
it required?
Very much, Lordship. Lordship may kindly come to page Page 4, Lordship.
What is the stage of investigation of the case?
Lordship, this
Not yet completed.
what happened, my lord, was on the last occasion, this honorable court has directed the state respondent to conduct through video. This honorable court has directed the state
That is
respondent-
true, that is true. You have already recorded the statement of
already
the,
recorded the statement. Lordship, however, recording the statement of the owner of the said vehicle, Lordship, it is found out that it is highly suspicious that the owner is also involved.
okay.
Lordship, may kindly come to page 6, Lordship, to make it very clear, Lordship.
Page
I
6
will
of,
only read the relevant paragraph
page 6
of the case diary, Lordship. I
Case
have
diary.
marked page 6, Lordship,
yes.
to make it clear, Lordship. Lordship, I will start from the second paragraph, Lordship.
Yes,
And he further stated that he was not feeling well during his stay in Imphal. So he booked the flight ticket on 24/7/2022 and departed on 25/10/2022 from Indigo service to Gauhati along with Narendra Kumar, leaving his seized vehicle at DRS Agrawal Packers and Movers in Imphal. Now the finding of the IO, Lordship. During the throughout examination, he stated that he did not know the person who was driving at the time of seize the vehicle, but the mobile number so-and-so, which was used to contact driver, belongs to Narendra Kumar, who was accompanying Devaram and helps him in driving as second driver. It is learned from his statement that he did not know the driver. However, during the CDR analysis of the arrested accused person, Abhijit Hazarika, the main accused, it is found that they are in constant calls through the common contact. Third, from the above statement, it is also learned from his statement that he paid rupees 500 to the Assam police for incomplete documents, and he couldn't be able to produce the original certificate of vehicle registration to the investigation agency in spite of several requests. He further stated that he was not in a position to drive the vehicle due to his health, that he left his vehicle to DRS Agrawal Packers and Movers Imphal. But the fact is that the second driver, Narendra Kumar, was still with him to help him in driving the vehicle. So it is crystal clear that Devaram, the owner of the said vehicle, who claimed to be the owner of the vehicle, was directly involved into the incident case, since he was unable to produce the original vehicle documents on several requests and afraid of appearing before the investigating officer for recording of his statement and evading from his arrest. During my investigation, it is also found that the Deva, along with his second driver, Narendra Kumar, reached Imphal on 21/7/2022, along with the seized vehicle, and halted at Classic Hotel Imphal from 21/23/07/2022. At the time of VC, in the presence of his learned counsel so-and-so, Devaram couldn't able to answer in detail to the investigation officer why he left his vehicle, very important, Lordship, why he left his vehicle in Imphal. And the best reason known to us is that he used his vehicle directly involved in transportation in smuggling of contraband items. Lordship, may kindly come to next page. Now, the vehicle documents which the petitioner provided to the investigating agency was a printed copy of the Parivahan application for mobile apps, and there was no any authority signature appended in the certificate of registration form, as well as owner details. And the registration records was not found in Vahan portal, which the RTO provided to the investigation agency. It is therefore the investigation agency requires the owner in person to present the original documents before the investigation agency for verification in order to bring out the fact about the seized vehicle. Since the vehicle was not seized for a mere suspicion, but on sufficient evidences and on reasonable ground that the vehicle was used to involve for transportation of illegal trafficking of huge commercial quantity of 10 10 packets suspected to be opium weighing approximately 10 kgs, which were recovered from inside the spare tire of the vehicle by the narcotic personnel on 29/7/2022. Also, during the process, the vehicle was booked under Section 60 of NDPS Act by the registering authority, and it is clearly mentioned in the Act that whenever an offense committed under this Act shall be liable to be confiscation. I therefore pray to your honorable court to kindly look into the above mentioned prima facie case under Section 60 NDPS Act 1985 as amended and confiscate the vehicle bearing so and so if deemed fit, Lordship.
Okay.
So Lordship may kindly come to page 1, Lordship. The first page, Lordship. This is the suo motu that was filed before the officer in charge narcotics cell PHQ, Kohima, Lordship. If you go to the content, Lordship, if I'm allowed to read the content, Lordship.
Please.
Sir, with reference to the subject cited above, I have the honor to state that on 29/7/2022 at around 2000 hours, having learned from the reliable source of information, the narcotics cell mobile unit party intercepted one vehicle Maruti Suzuki VXI Pearl Arctic white color bearing registration number AP39LK447
Okay.
17 chassis number so and so, engine number so and so, near bridge in between Kusama and Visama at NH2. The vehicle was coming from Imphal, Manipur towards Gauhati via Dimapur. And during frisking of vehicle, narcotic PS personnel detected and recovered 10 packets of suspected opium wrapped with brown tape weighing approximately 10 kg from the possession of one person, namely Abhijit Hazarika, male, age 24 years, so and so. The recovered and seized contraband suspected to be opium were found concealed, very important, concealed inside the spare tire of the vehicle belonging to the apprehended person.
Okay.
So it is a prima facie against the owner of the, and he is highly suspected to be involved, Lordship.
So, how many persons were arrested in connection with this present case?
As of now, Lordship, as of now, the accused, along with
the driver.
Yes, Lordship, the driver, Lordship. The driver who was driving the said vehicle when
Okay. He is still under the custody or he has been released? He has been enlarged on bail?
I think he might have released on bail, Lordship.
Released on bail, okay. So,
But here, the said owner,
Hmm.
Lordship, even the owner is not certain as of now, Lordship.
owner of what?
Owner of the vehicle, Lordship, in which they are praying for the Zima, Lordship. It's not certain. If you
the
go
person
to
who
the
is,
Bahan of the Lordship.
Yes, are you the
What?
owner has
May it
noted?
please your lordship.
Yes,
My lord, in this matter, my lord, the documents which I submitted in the court below has not been disputed. The only reason why my prayer was rejected in the court below was that my statement was not recorded. And now the Right Honorable Court's order, my statement has also been recorded in this particular case. I have, my lord, annexed all the documents which specifically clarifies my ownership with regard to the vehicle, my lord. And most importantly, if my ownership is not ascertained as what the state is submitting, my lord, then on what ground the state is saying that I may be involved in this particular case? So, my lord, this is a case wherein, my lord, it is only a case of Jimma, wherein a particular vehicle is in the possession of the investigating agency. The vehicle is lying in the premises of the, my lord, police station. And, my lord, because no one is attending the vehicle, my lord, that is why, my lord, as it was my vehicle and how and under what circumstances, my lord, I went to Manipur, I, my lord, fell ill and I booked a ticket, air ticket, my lord, which also I have annexed, my lord. And I have booked my car, my lord, in Agarwal and Packers to be delivered in Andhra Pradesh from, my lord, Manipur. And that is how, my lord, I have annexed that particular document also, that I have given delivery to the packers and movers, my lord, for delivery of my vehicle at Andhra Pradesh. Under that circumstances, my lord, the registration certificate also I have annexed along with my petition, my lord. So this particular case is only related to, my lord, whether the Jimma of the vehicle can be granted to me or not. Because, my lord, for the purpose of investigation, the question is, my lord, whether for the purpose of investigation, this particular document is required or not required, my lord. So, my lord, if my lordship permits me, my lord, I'm relying on a judgment of the Honorable Apex Court as well as a judgment of the, my lord, Honorable Gauhati High Court also, my lord. 2000, 2002, 10 SCC 283, my lord.
Yes, ma'am. 2000.
2,
Mhm.
10 SCC 283.
Okay.
This is division bench judgment of the Honorable Apex Court, my lord. Herein, the guidelines have been framed with regard to, my lord, Jimma of, my lord, the articles seized in connection with a particular case, my lord. In this particular case, my vehicle has been seized, my lord. And, my lord, if my lordship may kindly come to page number 287,
Yes.
para 7, my lord.
Yes.
May I read, my lord?
Yes, please.
Yes. In our view, the powers under section 451 CRPC should be exercised expeditiously and judiciously. It would serve various purposes, namely, number one, owner of the article would not suffer because of its remaining unused or by its misappropriation. Number two, court or the police would not be required to keep the article in safe custody. If the proper panchnama before handing over possession of the article is prepared, that can be used in evidence instead of its production before the court during the trial. If necessary, evidence could also be recorded describing the nature of the property in detail. And the jurisdiction of the court to record evidence should be exercised promptly so that there may not be further chance of tampering with the articles. Now, my lord, page 289.
Yes.
After para 14, my lord, the observation of the Honorable Apex Court with regard to vehicles. My lord, para 17.
Yes.
In our view, whatever be the situation, it is of no use to keep such seized vehicles at the police stations for a long period. It is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of the said vehicle if required at any point of time, my lord.
Yes.
And, my lord, lastly, my lord, para 21, my lord.
Yes.
May I read, my lord?
Yes.
However, these powers are to be exercised by the magistrate concerned. Para 21, my lord. However, these powers are to be exercised by the magistrate concerned. We hope and trust that the magistrate concerned would take immediate action for seeing that powers under section 451 CRPC are properly and promptly exercised and articles are not kept for a long time at the police station. In any case, for not more than 15 days to 1 month. This object can also be achieved if there is proper supervision by the registry of the High Court concerned in seeing that the rules framed by the High Court with regard to such articles are implemented properly. Now, my lord, there is another judgment, my lord.
Yes.
Gauhati High Court, my lord, 2003, 3 GLT 452.
Yes.
My lordship. Para 2, my lord. It has followed the proposition of the guidelines, my lord, framed by the Honorable Apex Court. Para 2, may I read, my lord?
Yes, please.
The Apex Court in Sundarbhai Ambala Desai versus State of Gujarat reported in AIR 2003 SC 638 in dealing with the disposal of the property pending the trial under section 451 CRPC held in para 7 that the power under the said section should be exercised expeditiously and judiciously. Number one, owner of the
No, no, no. Council, there is a crack in your voice.
Remain
No, Learning Council, your voice is cracked.
occupation, court or the police would not be required. I'm sorry, my lord. I'm sorry, my lord.
Link was down and then there was a
My lord,
in your voice.
am I audible now, my lord? Am I audible now, my lord?
Now it's audible. No.
My lordship, my lordship. My lord, para 2, my lord.
Yes.
The apex court in Sundarbhai Ambala Desai versus State of Gujarat reported in AI 2003 SC 638 in dealing with disposal of the property pending the trial under section 451 CRPC held in para 7 that the power under the said section should be exercised expeditiously and judiciously because it would serve various purposes, namely number 1, owner of the article would not suffer because of its remaining unused or by its misappropriation. Court or the police would not be required to keep the article in safe custody if the proper panchnama before handing over possession of article is prepared that can be used in evidence instead of its production before the court during the trial of necessary evidence could also be recorded describing the nature of the property in detail. And number 4, the jurisdiction of the court to record evidence should be exercised promptly so that there may not be further chance of tampering with the article. Now, my lord, this para is important and accordingly ruled that the court should pass appropriate orders immediately and articles are not to be kept for a long time at police station, in any case, for not more than 15 days to 1 month. Then, my lord, para 6, my lord, it was, this particular case was filed seeking jimma of a vehicle, my lord, and accordingly, my lord, the vehicle was granted jimma, my lord. Para 6, my lord, the factual aspect as well as the legal position of the case, my lord. May I read, my lord?
Yes, please.
I have carefully examined the impugn order on close scrutiny of the same as well as having regard to the above cited judicial pronouncement. It appears that though the vehicle has been registered in the name of Messrs. Purbanchal Banijya Vikas, the proprietor of the same firm has been named as Sri Vijayananda Chaudhuri, the petitioner, as evident from the police report dated 14/8/2003. And as such, the petitioner seems to be the owner of the vehicle, and accordingly, the petitioner has made out a prima facie case for his entitlement to the interim custody of the vehicle, my lord. So, my lord, my case is that, my lord, my vehicle was, my lord, seized in connection with the present case on 29/7/2022. And then, my lord, by order dated, my lord, 20/12/2022, my prayer was rejected, considering the fact that, my lord, my statement was not recorded. Now, my lord, in the court below, my lord, it has not been assailed by the prosecution side that the particular property is not belongs to me. And
No.
ownership was neither the ownership was disputed, my lord. In the first time in the court, my lord, during the pendency of my lordship.
No.
I'm sorry for the inconvenience, my lord.
So, according to the Learning Council,
my lordship,
the PP,
my lordship,
the vehicle was, it was booked under 60 of NDPS Act, lordship. And that whenever any offense committed under this act shall be liable to confiscation. So, you said that the ownership has also not yet been ascertained.
Not yet been ascertained, even they did not produce the original documents, lordship. So far, by the owner.
Okay.
And the owner is highly suspicious, lordship. Why? Because lordship at the time when
so now you have recorded the statement of the
lordship. We have already
his
recorded
statement under 161 CRPC.
Lordship.
Now you have also recorded the statement of other. You have also examined the other witnesses and recorded their statement. And from there, if there is any material evidence
No.
against the accused, what have you done? What steps you have taken? But then you say, keeping the vehicle.
Mm.
And then since you have not yet ascertained whether he is involved or not yet taken any steps, any further steps. If he is involved,
Lordship.
so he need to be arrested. You have not done anything now.
Lordship, but as far as the statement of the owner shows that he have paid 500 rupees, Lordship. Since at the time of traveling from Assam, Lordship, the owner did not carry the documents, Lordship. So because of that, he has to pay 500. That is the statement recorded through VC, Lordship. And that is the statement of the owner, Lordship. And moreover, Lordship,
what
he
are the
was with
problems?
the second driver also, Lordship.
Hmm.
And but as far as his statement goes, he says that after he reached Imphal, his health condition was not his health condition was deteriorating, Lordship. Because of that, Lordship, he has to leave that said vehicle to the Packers and Agrawal Packers and Lordship.
Now,
It's very contradicting.
no,
Lordship, the
maybe,
statement.
but then you say the question is the only question is that the vehicle is to be released and to the owner. Your problem is only that the ownership is not yet been ascertained.
And moreover, Lordship, they have not produced the original.
You want original, you know.
Yes,
to
Lordship.
release.
Investigating of the eye of the case want him to produce the original.
So if the original is produced, you are ready to release.
Lordship.
Okay, then why don't you produce the original document, RC?
As will produce, my lord, at page 15, my lord, sorry, my lord, at page 12, my lord. We have already submitted, my lord, the copy before the honorable court, my lord. This is certificate of registration, my lord, page 12.
Lordship, this is not in original, Lordship. If your Lordship
My lord.
see the
And my lord, page, and my lord, page 16, my lord, page 16, my lordship will find that I paid, my lord, 43,500 for, my lord, transport of my vehicle, my lord.
Lordship,
Page
that is not
16, my
a-
lord. This is Agarwal Packers and Movers.
Lordship may kindly come to, since the petitioner, they are relying on page 12, Lordship. If Lordship may kindly come to page 12, Lordship. This is not the original, Lordship. If
No,
you
this
go to the extreme right,
page 16 is Agarwala Packers and Movers. So
Lordship,
this is not
Lordship.
connected.
that is a different subject matter,
Hmm.
Lordship. As far as the
What is your RC? Have you annexed the RC, your RC?
16, my lord.
page
Where?
12,
Page 12.
16, my lord.
page
RC,
12.
my lord, page 12,
12.
issued by government of Andhra Pradesh, my lord.
But this is not in the original, Lordship. This has not been signed extreme right,
I'll,
Lordship. Lordship may kindly come to the extreme right.
You produce the original
Yes,
my lordship,
and then on production of the original, you release
Lordship.
my lordship.
with certain condition.
Lordship. My lordship. My lord, the only issue is whether this vehicle is required, my lord, for investigation. They have done everything, my lord. So in the court, my lord, during trial, they are not going to produce the vehicle. They'll produce only the JIMA memo, my lord. So, my lord, that is sufficient for the purpose of, my lord, trial, my lord. What purpose will it serve, my lord, if my vehicle is kept lying in the premises of the, my lord, police station, my lord, lying unattended, my lord, decaying day by day? Honorable court may fix any condition, my lord. I'll comply, my lord, and I'll get back my vehicle, my lord. And my lord, if necessary, I'll produce the vehicle as and when required again, my lord. If required for the purpose of investigation, my lord.
Okay. Let them produce the original
Okay.
My lordship.
Then counsel for the petition.
MK Das, my lord.
Mr. M.K. Das.
M.K. Das. Deeply obliged.
Also heard. Mr. V. Jimomi, learned additional public prosecutor,
Public prosecutor.
or public prosecutor for the state of Nagaland. This is an application under section 482 of the Code of Criminal Procedure, 1973, read with section 401 and section 397 of this Code of the Criminal Procedure for setting aside quashing of the order dated 2012-2022 passed in IA Jimma 305/2022 in connection with special case number 17/2022 arising out of Kohima narcotic sale PS case number 8/2022 stop. So this was registered under what section?
In the section 18B 60 NDPSA.
Okay, under section 18B/16 of the NDPS Act 1985. The case of the petitioner is that he is the owner of the seized vehicle, Maruti Suzuki Swift VXI vehicle bearing registration number AP -39 LK 4717, stop. The said vehicle was booked for transportation from Manipur to Hyderabad. It was from transportation from Manipur to Hyderabad. Hello.
Andhra Pradesh, my lord.
Okay. Andhra Pradesh means Hyderabad.
My
Pradesh.
lordship.
Manipur
My
to
lordship.
Pradesh through private.
Hyderabad, my lord.
Okay.
Hyderabad, my lord.
Hyderabad, Andhra Pradesh through
My lord.
private
My lord.
transporter, namely Agarwal Packers and Movers. On which date?
My lord, 24/7/2022.
7/2022. Stop. However, the petitioner later on came to learn that his said vehicle was seized by which police? Nagaland police. Nagaland police in connection with narcotics sale PS case number 8/2022 under section 18B/60 of the NDPS Act 1985. And presently, the vehicle has been kept in the narcotic cell police station complex at Nagaland. Nagaland or Dimapur, where? Which place? Where it has been kept? Dimapur or?
Kohima.
Okay, Kohima, stop.
my lord.
The land council for the petitioner submits that the owner of the vehicle is innocent and he does not know, he does not have any knowledge about the misutilization of his vehicle. Knowledge about the involvement of his vehicle in the above noted narcotic seller, above noted PS case number 8, 2022. Stop, huh? It is the case of the petitioner that he made an application, he made an application, he made an application before the Land Special Judge NDPS Kohima under section 451 CRPC, praying for release of his vehicle on Jimma. However, by an order dated 2012-2022, the Land Special Judge NDPS Kohima rejected his prayer, or rejected the said application. So, rejected his application with further observation that the manner in which the accused came to be in possession of the seized vehicle is dubious and suspicious. Stop. Huh? With further observation, further. Huh? What is your contention in your additional affidavit? So this is additional affidavit of the petitioner only.
Lordship, this is
My
the
lord,
this is the case that is.
No. Additional affidavit is also there.
additional affidavit we filed, my lord, because, my lord, on the last occasion, my lord, the prosecution side has submitted that even after, my lord, the honorable court directed for, my lord, recording of the statement through video conferencing.
Okay.
My lordship.
It is the further contention of the land council for the petitioner that as per the direction of this court, now the statement of the petitioner has also been recorded by the police and his said vehicle is no more required by the investigating agency, which is lying unattended since July 2022, without any maintenance and repairment, due to which the condition of the vehicle has deteriorated to the extent that it would get damaged if the custody of the same is not given to the petitioner at an early date. The learned counsel for the petitioner has taken a reliance upon the decision of the Honorable Supreme Court in 2002, 10 SCC 283. Between
My lordship.
Sundarbai Ambalal Desai versus State of Gujarat. Wherein it, it is, which is reproduced there in below, stop. Para 7, in view of.
Para 7, my lord.
Para 7.
And 17, my lord.
17. Okay.
And period, my lord, that has been stated at para 21, my lord. Time frame, my lord.
Okay. And 21, okay.
My lordship.
I think that is sufficient.
My lordship, my lordship. Highly obliged.
Okay. Stop. Para. On the other hand, the learned EP, Mr. Jimomi submits that Jimomi, while producing the case study of the narcotic case study of the narcotics LPS case number 8, 2022. Submits that there is every possibilities that the present petitioner, who claims to be the owner of the vehicle, is involved in the commission of the alleged offense in the case. Stop. He further submits that the petitioner has never produced, has not produced the original RC of the said vehicle to be claimed to be, although he claimed to be the owner of the said seized vehicle. Stop. However, he submits that
the owner as well as the accused were also in constant touch, Lordship. If you go by that.
that is about the case only, but then here we are concerned with the Jima. No. However, he submits that in case the petitioner produced the original certificate of the registration for earlier, that one, not yet produced the original certificate, due to which the owner of the said seized vehicle could not be ascertained till date. Stop. Thereafter, this, however, the learned people submit that if the petitioner produced the original certificate of the registration of the said vehicle is produced, the same shall be released on condition that he produced a vehicle as and when required. Stop. In view of the above, and as agreed upon by the land councils for the parties, I am of the view that the seized vehicle bearing number, all those, bearing numbers, you have the number now, AP39 LK471 17. Sorry, is this a number? Okay, number we have recorded earlier. Okay, number so and so on production of the original certificate of the registration with the further condition that the petitioner shall produce the vehicle as and when called for, as and when required by the police or the court. Stop. That's all I think. With the, any other?
My lord.
Lordship. With the above.
My lord, may I pray for a liberty, my lord, that my lord complete the conditions of the honorable court, my lord. I may be allowed to my lord comply through my lord my authorized representative, my lord.
That is okay, only provided he produced the original certificate.
Lordship.
My lordship.
Lordship, let the owner produce the original certificate.
No, if the owner is not is implicated,
my
then
lord.
why you need the owner only? Any representative can. Okay.
Deeply obliged, my lord.
The petitioner is also given liberty to produce the original certificate through his representative, certificate to the police station, to the investigating agency through his representative. Stop. with the above.
and
Yes.
take the custody of the vehicle, my lord.
Hmm. Okay. So when it is released, it will be under your custody only.
My lordship, my lordship.
With the above, this application stands disposed of. With the
Deeply
above-
obliged,
Okay. Obliged.
deeply obliged.
For admission, item number 10.
May it please, my lord.
Hmm.
Your lordship,
Yes.
your lordship, it is my humble prayer that this matter may be listed after 3 weeks, your lordship, because
Item number
item number 10,
10, okay. You are for the petitioner.
yes, I'm for the petition.
Okay. You are protected.
Yes, your lordship. I have fulfilled the bail conditions, your lordship.
Hmm?
I have fulfilled the bail conditions.
Okay. Have you surrendered before the police? Have you been
Yes, your
arrested?
lordship, yes, I have appeared before the police on 4th of October.
Whether you have been shown arrested?
Yes, your lordship, and I have also accordingly signed a PR bond, your lordship.
Pierre Bond. Do you have the copy?
No, your lordship, unfortunately,
Pierre Bond signed.
yes, your lordship. Then your lordship, can you list this matter tomorrow? It may be possible.
You produce that.
So that I would.
No
produce the
point
PR
keeping it
bond, your
pending.
lordship, that I have
The
signed.
case seems a petty cases.
Yes, your lordship.
Okay. Is prayed for by the land council for the petitioner, Miss
Vitere.
Hmm?
Vitere.
Vitria. This is method, and okay, hard land council for the petitioner, Miss Vitria, also hard land PP, Mr. And,
Vijumom. Vijumom.
Jimomi, no? Jimomi is PP, no?
No.
Angami,
Ngami is also here.
PP, okay,
We have
Jimomi, staff. Is prayed for by the land council for the petitioner, list this matter tomorrow.
Yes, your lordship. Deeply obliged.
For orders, item number 12.
Yeah, please, Lordship.
Yes,
Lordship, here, with regard to the previous order of passed by this honorable court, dated 12/10/2023, we have taken steps upon the respondent number 4, Lordship, through paper publication. And it has already been published, Lordship. However, Lordship, if this honorable court may kindly grant us 2 weeks' time, so that we can file our affidavit of service. For respondent
Okay.
number 4.
land council for the applicant, Mr. Mr.
Medovero, Lord.
Medovero,
Yes, Lord.
who submits that he has taken steps upon the respondent through alternate.
Four.
Oh,
Respondent number 4.
oh. Taken steps upon the respondent number 4 through substitute mode of service by publishing in the paper, local newspaper,
Assam, Lordship.
okay, paper. And praise for 2 weeks' time to file an affidavit,
Affidavit of service.
affidavit of service, start. They are allowed. List matter, the list is matter after 2 weeks,
3 weeks, Lordship.
3 weeks.
Yeah.
Okay,
Obliged, my lord.
over.
transport